Today you're saying something?
Yes, ma'am.
You're saying something, I missed.
Yes, ma'am. I'm sorry. Lord, I was to start,
Yes.
but my learned friend, my Lord, who was arguing on the last occasion, I requested that he has few minutes to argue. I'll argue, my Lord, after he completes.
Sure.
There's one item 501.1 as well, Milots. I would like to address just for 5 minutes because that arises out of section 9, Milots, not under 11 and 8. 5.
Please, my lord, before he commences, Mr. Sibbal had concluded his arguments on Thursday,
Yes.
seeking permission to file a note on arguments on his behalf.
Yes, you can file that.
Great.
And email a soft copy to the court master.
Yes.
Because I had submitted a note,
You're in IA 58168.
my lords.
Yes, Ms. Monge.
Because I've tried to deal the questions that have fallen for my lords in the last 2 dates. The first question that fell for my lords is how do you infer conduct under section 7? Where is the rule for conduct? My lords, in my humble submission is, my lords, that the provision of section 7 is pari materia to the New York Convention, Article 2.2. And generally, there's a handbook of judges which International Council for Commercial Arbitration's guide to the interpretation of the New York Convention.
You have made some submissions? Have you circulated? I'm just asking.
Yes, Lord.
I've circulated a note, my lords.
What's under what?
Written submission, Pallav Mongia.
The hard copies also.
Yeah.
So there's a handbook for judges.
Yes.
My lords have it, no? Which contains a checklist setting out the questions to be answered and the steps to be followed by courts when applying the New York Convention. In relation to Article 2.2, it lays down the following. Is the arbitration agreement evidenced in writing? Examples is the...
Mr. Babu,
Sorry.
you are reading from where? I'm not got it. It's your compilation on behalf of the intervener?
Yes. My lords, there's a compilation also. I've put the entire...
Written submission. All right.
Just to save time, I was reading from the note only which I've extracted. The relevant portion I've extracted.
Just a minute.
He is Sanjay Ghosh. Written submission.
Yes, Lord.
IA 58168. Got it.
Mila ko?
Mila.
It's in.
Correct.
This one.
Correct.
Yes.
My lords, it's the International Council for Commercial Arbitration's guide to the interpretation of the New York Convention, para 2 in my note, my lords, where they've laid down a checklist setting out questions to be answered and steps to be followed by courts when applying the New York Convention. In relation to Article 2.2, it lays down the following, and the provisions are pari materia, Section 7 and Article 2.2. Is the arbitration agreement evidenced in writing? Examples, is the arbitration agreement incorporated by reference? Has the arbitration agreement been tacitly accepted? Similar is the position in UK law also. My humble submission is that the concept is not restricted to signatories, but is open to interpretation. And that conduct has to be inferred from anything which is evidenced in writing. That is the test. So it excludes oral agreements. Orally, one can't come to court and say, look, there was an arbitration agreement. But as long as there's something evidence in writing from where one can infer the conduct, that will fit into the description section 7 blocks.
UK law 5.
And UK law also, my lords, in section 5, subsection 4, an agreement is evidence in writing. If an agreement made otherwise than in writing, it's recorded by one of the parties or by a third party with the authority of the parties to the agreement. So oral agreements are barred, but anything evidenced in writing should be enough to infer the conduct of the parties.
Right.
And there are 2 instances where my lords have given liberal interpretation to the arbitration agreements. One is a Trimex judgment, which I've quoted here. Second is one Govind Rubber. It's of 2005. I'll just read the relevant parameters. It's very useful. Perusal of the aforementioned provisions would show that in order to constitute an arbitration agreement, it need not be signed by all the parties. Section 7.3 of the Act provides that the arbitration agreement shall be in writing. which is mandatory requirement. 7.4 states that the arbitration agreement shall be in writing if it is a document signed by all the parties. But the producers of clauses B and C of section 7.4 would show that the written document which may not be signed by parties, even then it can be arbitration agreement. 7.4b provides that the arbitration agreement can be cut out from an exchange of letters, telex, telegrams, or other means of telecommunications which provide record of the agreement. So that's how the expression record of the agreement has been interpreted. And it's akin to evidence and writing. That's my humble submission. And that's how the concept of implied consent is also borrowed. Para 6 I've reproduced from Gary Bonmilot. The entire chapter is very interesting. I've reproduced the entire chapter in my compilation. Coming to section 8, Milods, interpretation of section 8. Because one of the main arguments that was made under section 8 was that there's no power vested in court under equity, and therefore equitable principles cannot apply. My response to the same is that these arguments come forth when the judicial fora or the courts are creation of that very statute. So they are bound by the powers given in that statute. But this is a case where courts are not creation of the statute or judicial authorities. They're already pre-existing under some provision. They have inherent powers. This act just gives an additional charge to those courts and says, look, you can exercise these powers also. For example, the arbitration tribunal's powers are restricted. And where they wanted arbitration tribunal not to apply principles of equity, they have mentioned so in section 28.2. I have not reproduced the provision, but 28.2 clearly states that arbitration tribunal will apply principles of equity only when the parties agree so. So no such exclusion is made in section 8, Milods. Thus, section 28.2 of the Arbitration Conciliation Act states that unless the parties expressly authorize the tribunal to decide ex equo et bono or as amiable compositor, the tribunal cannot decide on the principles of equity. Alternatively, Milods, my submission is that the application of principles like lifting of the corporate veil or third parties or looking at the intent is not a concept of power. It is a concept of application of legal principle.
Okay.
For example, the lifting of the corporate veil, it's not a power vested in any particular statute like Companies Act, etc. But courts, while interpreting various statutes, resolving disputes which come before them, they apply the principles of corporate veil. For example, the Constitution Bench judgment of LIC versus escorts. I have reproduced in para 3, B3, Milods, page 4 of my submission. This is a case which pertained to FERA. And there was no express provision, unlike the taxation statutes, which specifically provide for lifting of the corporate veil. In FERA, there was no such provision. Yet, the court was called upon to lift the corporate veil and see who's the owner. Similarly, industrial disputes also. The tribunals specifically try to find out who's the employer. And for that, if they have to lift the corporate veil, they lift the corporate veil. If I may just read this para 90 from LIC versus escorts. It was emphasized that regard must be had to the substance and not the form of a transaction. Generally and broadly speaking, we may say that the corporate veil may be lifted where a statute itself contemplates lifting the veil, like a taxation statute, or fraud, or improper conduct is intended to be prevented, or a taxing statute or a beneficent statute is sought to be evaded, or where associated companies are inextricably connected as to be, in reality, part of one concern. It is neither necessary nor desirable to enumerate the classes of cases where lifting the veil is permissible, since that must necessarily depend on the relevant statutory or other provisions, the object sought to be achieved, the impugned conduct, the involvement of the element of public interest, the effect of parties who may be affected, etc. So statutory power is not the test. The application of principle will happen if such situations were to arise before the court.
Thank you. Then now we'll read the rest of the.
Just one last submission, Milods. I'll just take 2 minutes. Milods, what I've also done is, Milods, I straight away have page 7 of my submission. I've put in a table where US courts have applied various principles to involve third parties in arbitrations. A submission was made previously, Milods, that US courts don't recognize group of companies doctrine. But that does not mean that they don't extend the jurisdiction to non-signatories. These are various instances where they have extended jurisdiction to non-signatories. my lords. One important is, my lords, CCL number 1, Alter Ego. Shapoorji Pallonji Company Private Limited versus Rather India. There's a Delhi High Court judgment where they actually analyze the US law and says that, look, these principles are applicable in Indian jurisprudence as well. May I just direct my lord's attention to the compilation. Once may have page 172 of my compilation. Just may have straight away para 24 and 25 on page 178. My lords have it, my lords?
Yes.
He first quotes Gary Bond. According to Gary Bond, the principal legal basis for holding that the non-signatory be bound by an arbitration agreement is to include both purely consensual theories, example, agency, assumption, assignment, and non-consensual theories, example, estoppel, alter ego. In several cases, implied consent is used as a basis to hold that non-signatories are bound by the arbitration agreement. It is well settled that in cases where the signatory is an agent of the principal can be compelled to arbitrate, even though it is not a party to the agreement. This rests on the principle that the arbitration agreement may not have been signed by non-signatories, but was executed on its behalf. This principle is applied essentially in cases where agent-principal relationship is established between the signatory and the non-signatory, and it is established that the signatories had acted under authority of the principal. There are several cases where the courts have found the conduct of the signatory and its principal to be sufficient evidence of the relationship. And then they quote other instances where other principles apply. For example, the quotation para 26, where a party conducts itself as if it were a party to a commercial contract by playing a substantial role in negotiations and or performance of the contract, it must be held to have impliedly consented to be bound by the contract. And then they go on refer to other cases. Gary Bond is referred again, para 29. Para 31, there's an important quotation. The court observed to allow plaintiff to claim the benefit of a contract and simultaneously avoid its burdens would both disregard equity and contravene the purposes underlying enactment of the Arbitration Act. This is where the principle of equitable estoppel comes in. And in the next para 32, a non-signatory may be stopped from avoiding arbitration where it knowingly accepted the benefits of an agreement with an arbitration clause. The benefits must be direct, which is to say flowing directly from an agreement. And then they go on analyzing Dow Chemicals. I'm skipping all of that. I mean, also the US Supreme Court judgment is very important, para 37, where again they apply principles of equity estoppel. And then they repeat all the MTNL cases and all. And they conclude that they need not rely upon group of companies doctrine to reach their conclusion. There are other principles which are actually taken out of principles of contract, agency, and corporate law principles and equity to reach the same conclusion. My concluding submission is, my lords, that my lords are deciding the scope of group of companies doctrine, but my lords may consider that non-signatories should not be completely ousted from because of the ruling on group of companies doctrine. There are other tools available in the statute which permit application of addition of non-signatories to that. I'm highly obliged.
Thank you, Ms. Mongia.
It's 501.1, my lords, arises out of a section 9 petition.
That is seal number. What's your I number?
No, it's not an IM, it's 501.1. It's an SLP itself, my lords, which has been tagged with this matter.
SLP number?
It's SLP number
07.
8607 of 2022. That's 501.1, my lords.
Yes.
but that is arising out of section 9, my lords, whereas the reference query is query section 8 and 11. So, my lords, that matter, my lords, should be detagged in my humble submission, my lords.
Your matter.
Yes, my lords, because that is specifically arising only under section 9.
My matter. I am the petitioner in the matter. I'm appearing for the petitioner, Mr. Khambata.
I appear for one of the respondents.
One of the
It's a
respondents.
little late in the day for my learned friend to get up at this stage and say, detag it.
He's appearing for respondent 1 and 2.
I do.
Just that we are on this side of the table because the proposition that we advance is a proposition which is
that's okay.
All right.
distinct from the proposition.
You're
on
only
the other
seeking
side.
leave to make submissions on law before your lordship.
Yes, yes.
There's going to be no foray into the facts at all.
That's
All
right.
right, we'll,
Then, my lords, hear me for 5 minutes on section 9, because, my lords, section 8 and 11.
let's hear them and then you can.
Then I'll wait for me.
All right.
Yes, thank you.
Wait, please, Your Lordship.
Yes, Mr. Solicitor.
Lord, I'll just, my Lord, since now there is an addition of counsels, my Lord, on this side, I'll also have to, my Lord, compress the submission so that Your Lordships may at least, my Lord, attempt to conclude on this today.
Small.
Finalize that late night, my Lord.
Why don't you mail it to us? Mail it to the court master first, or do you need to mail it to the court master? If you immediately mail it to us,
I'll immediately do
and drop it in.
Lord, I'll just, Lord, give 6 propositions. Lord, I am appearing for the Union of India. I am indeed grateful that Your Lordships allowed me, my Lord, though I am not a party. But Your Lordships have 2 extreme positions. One saying that it applies completely, and one saying that it can never apply. And there is an exclusionary exclusionary statutory mechanism. That's one side of the argument. Lord, my argument will be nuanced arguments because we want this act to become effective and functional. And it does not become effective and functional if disputes are fragmented.
Yes.
Lord, 5 points, my Lord. I'll just very briefly take Your Lordships to the history as to how, my Lord, this act came to be enacted. Because, my Lord, some arguments are bound to be made. They were made on this side, will be made on that side. That some jurisdictions have accepted, some jurisdictions have not accepted this doctrine. That will be the first limb. Second limb would be that in my respectful submission, the doctrine of group of companies is intrinsically inbuilt in the statute itself. And I'll attempt to show that. There is no exclusion in the statute. There is no exclusion of this doctrine. It is there. Third,
Sorry, what was the first point?
Lord, first was a general history, my Lord,
Yes.
because that would give Your Lordships, my Lord, assistance as to how to interpret, my Lord, our statutory mechanism in arbitration.
All right.
Second would be, my Lord, that doctrine, group of companies doctrine is intrinsically inbuilt in the statute itself.
Yes.
Third, presuming that the act excludes that doctrine or act does not at least include the doctrine, but my submission is going to be that doctrinal approach, Your Lordships have always evolved. Everything is not to be found in the letter of law. Your Lordships infuse blood and soul by developing doctrines for interpretation of the statute as it stands. And that's how, my Lord, the law evolves. Fourth, my Lord, how other jurisdictions have treated doctrine of group of companies and what are the parameters, what are the contours they have relied upon. But ultimately, my lord, ultimately the bottom line of all these jurisdictions would be that your lordships may perhaps be able to lay down illustrative cases if your lordships accept the doctrine, but eventually it will be a case-specific determination if the doctrine is to be applied in our act. And last, Lord, what would be if your lordship is subject to what your lordship ultimately decides, whether the doctrine applies in our Indian scheme of statute or does not apply, but if it applies, what would be the contours of the court's jurisdiction under Section 8 and the jurisdiction of my lord the Chief Justice or his lordship's designate under Section 11, subsection 6? To what extent, my lord, the examination would be required at that stage?
Yes.
Yes, my lord, since my lord, there are other, my learned friends are also, my lord, I'll compress it, and what may not be directly relevant, my lord, I'll point out briefly. Lord, first of all, so far as history is concerned, your lordships are aware, whatever is relevant for the present dispute. Lord, this alternative dispute mechanism concept started in 1923 with Vienna Convention. Geneva Convention, I'm sorry. Geneva Convention, 23 and 27. But it was too broad-based mechanism, and in fact, it was not a mechanism at all, which led to eventually New York Convention. The New York Convention essentially dealt with enforcement of foreign awards. There was no mechanism provided as to how to arbitrate. What are the powers of the arbitrator? What are the rights and responsibilities of the parties? What will be the substantive law? What will be the procedural law? What will be the curial law, etc. Nothing was done in New York Convention earmarked, but 172 states, my lord, in the context of international law, 172 countries adopted the New York Convention. Lord, that a global need was found that there has to be a model infrastructure which can be adopted by the states and which can become their respective domestic statutory law. And there comes, Lord, unicitral model law. United Nations, my lord, prepared a model law in 1985, amended in 2006. Lord, there are 82 countries which have adopted the model laws, including India. Lord, why this is necessary? Broadly speaking, globally, there are two bifurcations or two divisions. One, who have their domestic law in tune with or in conformity with unicitral model law. They are broadly referred to as model law countries. And others, they go by their own domestic law. They have their own laws, may or may not be in conformity with unicitral law. Even if it is in conformity, it's not because they have adopted or assented to or become a signatory. They have picked up some issues. So there are two broad classifications of the countries. Now, my lord, I come to the main issue, Lord, my respectful submission and the first submission, that this doctrine is inbuilt in the statute itself. And there is no exclusion, my lord, as argued. My lord, if I am right in reading the provision the way I read, then, my lord, we need not find anywhere else any provision for exclusion or inclusion. It is included, impliedly, intrinsically. Lord, kindly, therefore, on this point, come to page 2. I have quoted, my lord, some of the provisions to, my lord, make myself, my lord, more clear. As pointed out above, the Act uses certain terms, expressions, and phrases very broadly so as to not reflect the scope of alternative dispute redressal mechanism in minimum category of cases only. By way of an example, the term international commercial arbitration as defined under section 2(1)(f) broadly takes within its wide sweep all arbitration relating to, please mark this, my lord, something would turn on this, my lord, therefore I have underlined it, dispute arising out of legal relationship, whether contractual or not. Lord, very widely worded term, any kind of relationship, if it gives rise to or give birth to a legal relationship, and irrespective whether it is contractually incorporated or not, it would become a subject matter of international commercial arbitration. So now, Lord, why I pointed out the unicitral model law which we have adopted. Unicitral model law essentially dealt with and deals with international commercial arbitration. The respectful submission is the commercial element of any dispute or a business sense element of any dispute is implicit, it's intrinsic in our act also. Though our act is not restricted to commercial disputes. There can be other disputes as well. Now, please come to para 6. Coming to domestic arbitration, also it is clear that the group of company doctrine has remained inbuilt in the scheme of the Act before and after Law Commission's report number 246 and the amendment made in the year 2015 based thereon. Firstly, the term arbitration agreement is consciously not defined either under Section 2 or elsewhere so as to include only an agreement in conventional sense of the term as used in Indian Contract Act or elsewhere. The legislature has very consciously avoided a restrictive definition which gives a conventional meaning to the term agreement, that is, a document executed by the parties at the foot of which the parties would put their signatures. Lord, nothing prevented the legislature from saying that arbitration agreement would be between parties who will be the signatories to the arbitration agreement. The definition says this one. And in my respectful submission, it reflects the legislative intent. Arbitration agreement means an agreement referred to in Section 7. Am I with your lordship?
Yes.
At this stage, for the present purpose, the definition of the term parties as used in Section 2H needs to be examined. Section 2H reads as under, party means a party to an arbitration agreement. So agreement is not defined. Agreement means whatever takes color of an agreement under Section 7. And the party is also not defined except to say that whoever falls within 7 will be a party for the purpose of this act. on true, meaningful and purposive interpretation of the Act, that is speedy, less time consuming, comprehensive, unfragmented and effective resolution of all disputes, it becomes clear that Section 7 itself statutorily recognized group of companies doctrine. The key word in my respectful submission is unfragmented dispute resolution. I have a dispute with A, but B is also a part of that dispute. So don't fragment it merely by giving a restricting meaning that I will have relationship with A and therefore arbitration between me and A, but for B I have to file a suit. That's not the intent. Now please see, my lord, the definition of the arbitration agreement. Lord, I have quoted section 7. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. I would respectfully read, my lord, subsection 1 like this. Arbitration agreement is an agreement made by the parties when you can show that there is a defined relationship. It need not have contractual foundation. Then it would be an arbitration agreement. Not necessarily between A and B, not necessarily having a contract between A and B, reduced as a contract between A and B, not in the conventional sense of the term agreement as used in the contract. Now, your lordships can do. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Well, we are not concerned for this matter. 3, an arbitration agreement shall be in writing. Lord, Mr. Sybil laid emphasis on this, my lord, and read 4A with that. It will have to be in writing. And it is so. Lord, I can't dispute that. Now, please see 4A. An arbitration agreement is in writing if it is contained in a document signed by the parties. This is the first kind of arbitration agreement. This is not the only kind of arbitration agreement. If it is signed by the parties, then it is an arbitration agreement. But B, Lord, if the legislature would have stopped at 4A, possibly the restrictive meaning was possible. That it has to be signed by the parties, it should be in writing, and that document only creates a legal relationship. Defined legal relationship. But please come to B. Now, there is no, my lord, arbitration agreement as contemplated under 7.4a. An exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. Please, my lord, mark, which provide a record of the agreement. Lord, in my respect,
Record of the agreement would mean from which you can deduce the essential terms of the.
I'm obliged, my lords. I could not have put it that succinctly. My respectful submission is the record of the agreement means any act of agreeing to certain things, not agreement in the conventional sense. So, my lord, if there is an exchange of correspondence between A, B, and C, the contract may be between A and B, but the correspondence reflects that C also understood the contract to mean that he will also perform some part of the contract. And I'll show, my lord, how such instances have happened. I'll show very, very briefly. But suppose back-to-back contracts, that during the correspondence between us, I say that I'll supply to Mr. Khambata and Mr. Khambata will in turn supply to Mr. Nakul Dev. The arbitration may be between the two, the agreement between the two of them. But during the correspondence, it comes out that I have also agreed to certain things to be done in a certain way, then not merely because I am not a party to the arbitration agreement or arbitration clause, if it is a separate agreement, but I cannot say that now I can't be joined in your. Otherwise, my lord, the legislature would have used a very simple language. Arbitration agreement means an agreement between the parties to the dispute. And the parties would mean signatories to the agreement.
Yes.
So, my lord, my respectful submission is the term parties are not used in the same sense as we understand signatories. You can be a party without being a signatory to an arbitration agreement or a substantive agreement which contains an arbitration clause. Now, my lord, kindly see page 4, para, at the foot, para 11. The concept of business prudence ingrained in section 2(1)(f) for international commercial arbitration is again inbuilt and ingrained in section 7. Section 7 neither restricts the term agreement to be one conventional document nor restricts it either document-wise or party-wise. It uses a broad expression defined relationship, whether contractual or not. This is clearly suggestive of the legislative intent that any kind of legal relationship, even if it is not contractual, that is, there is no contract between the entity, my lord. I am not using the word party or signatory. Between the entity whose actions or participation results in a defined relationship can form the subject matter of an arbitration agreement. That's why this wide definition consciously chosen. 12, my lord, I have already pointed out. 13. Section 7(4) mandates an arbitration agreement to be in writing. The conventional agreement which comes to one's mind, that is a written document describing inter se rights and liabilities between the signatories to the document, bearing the signature of such contracting parties in such agreement, is placed in section 7(4)(a) as a separate and distinct category. Now, next, the said agreement contemplated under 7(4)(a) is, however, not restrictive, but will be guided by 7(1). So, my lord, there can be, my lord, kindly pause here for a minute. There can be an agreement which is under 4(a), document signed by the parties. I'm sorry, 7(4)(a), which is a document signed by the parties, but it will have to be examined under 7(1), because it can be an agreement where it clearly comes out a defined relationship which may not be contractual under this agreement. Lord, I hope, my lord, I am able to make myself clear. My lord, continuously, my lord, I am saying, my lord, in their contract, Mr. Khambata and Mr. Devan's contract, they continuously refer that the goods will be supplied by Mr. Mehta. I am not, my lord, a document signed by the parties. I am not a signatory to that document. But from the document, it emerges that there is a defined legal relationship emerging from that document. Like, for example, there are certain obligations incorporated by reference. They can say, Mr. Khambata can say that I'll supply goods to Mr. Devan, but we have a separate agreement dated so-and-so, registered at so-and-so with Mr. Mehta, and he has agreed thereby that he would supply the similar goods to me, which I will supply to him. So
I may not have bargained for a contractual relationship between you and Mr. Devan, in your example.
Yes.
Unless there is a tacit acceptance by you of the obligation which Mr. Khambata has assumed to supply goods to Mr. Devan, you would not be liable.
No,
Merely because, say, suppose, for instance, you are the foreign collaborator of Mr. Khambata's client. All right, that you you are the person who has prepared the software, or you have prepared the service agreement, the license agreement. You are the real originator of it all. Unless there is something to indicate that, look, you have assumed the obligation, or that you stand behind the obligation which Mr. Khambata has assumed to.
I vowed. That is why I emphasize it must emerge a defined legal relationship with respect to the dispute. I'll just give an example, simpler example. Look, Tata Steel is a Tata group of companies.
Yes.
Tata Motors is a Tata group of companies. Suppose Tata Motors enters into an agreement with me for buying certain products, tires, machinery, etc., etc., and there is a dispute between the two of us. I can't involve Tata Steel saying that it's a group of companies. If he is unable to pay, you pay. But if there is a defined legal relationship with third person, and that is how the courts have construed, defined legal relationships are presumed under various doctrines which your lordships have evolved in other jurisdictions also. Back-to-back contract is one such thing. It would be a fact-specific determination.
Right.
There would not be any straight-jacket answer. But the point I am respectfully urging for your lordship's consideration is there is no exclusion. In fact, Section 7 incorporates group of company doctrines by not restricting it to mere parties to the agreement, except in 4.1a, 7.4a, but it restricts even correspondence. There can be a correspondence that, all right, we supply, they supply, etc., etc. Now kindly come to page 10. It is thus clear that even if there is a contractual document in existence between party A and B, as contemplated under section 7.4, I'm sorry, page 6, page 6. It is thus clear that even if there is a contractual document in existence between party A and party B, as contemplated under section 7.4a, if both of them have a defined legal relationship with entity C or D, qua the dispute, not some other relationship. I am now restricting to give a purposive meaning, my lord, and to ensure that it doesn't become an unruly horse where anybody and everybody is included. Qua the dispute, an arbitration would take place amongst A, B, C, and D, irrespective of as to whether A, B, C, or D are contractually connected with each other, or irrespective of whether C or D are signatories to the document contemplated under section 7.4a. Well, this is the crux. So parties are not to be read as synonymous of signatories, and the existence of a defined legal relationship can be inferred from the correspondence also. Lord, kindly come to, ignore 14, come to 15. Lord. Section 7.4b, however, makes above referred legislative intent more clear. It specifically does away with mandatory existence of a conventional document only to be regarded as an arbitration agreement. Under the scheme of 2H and 7, even exchange of letters, telex, so and so, is an arbitration agreement if it provides record of agreement based upon a legal relationship. Now, my lord, next is relevant, as my lord very succinctly, my lord, fell from my lord the Chief Justice of India, the subpara.
Yes.
Subpara. In other words, the term agreement, except as used in section 7.4a, that is document signed by the parties, is used not in the conventional sense of a document of agreement with signatories, but as an act of agreement. This is, my lord, the heart and soul of section 7. Whether contractual, not contractual, if it gives rise to a defined legal relationship and there is a reflection of some act by even non-signatory agreeing to something by each and every mode, whether contractual or not, and may be between more parties if all of them constitute a legal relationship in a transaction. This is how, my lord, the letter of section 7 will be infused with spirit and blood by your lordships by interpretation.
No, Mr. Mehta,
My lords.
see, the contract, the correspondence between A and B, and what they decide is, it is the C who will supply. But C is not a signatory, the example that you have taken. Now, unless there is a conduct in furtherance of the contract between A and B by C, you can't rope in C. There has to be a conduct.
Your lordships are right.
And the conduct is in furtherance of the contract between A and B, although C is not a signatory. So therefore, just the correspondence between A and B will not drag in C under the group of...
I bow down. Your lordships are right. My lord, the example which I would wish to give to buttress my argument would be this. What is essential is something should emerge to be a defined legal relationship. Number one. Number two, it need not be a document signed by two parties as an agreement. It can be exchange of letters. Now, in the same example which my lords were pleased to give, Lord, suppose there is a correspondence between A, B, C, A to C, C to B, B to A. And if it can be found out that because of this correspondence, though the arbitration clause is only between A and B, but C has also participated. He was a part of the negotiation process. He also given certain assurances, etc. Then C cannot say that I am not a signatory to the contract between A and B, and therefore I cannot be a part.
Therefore, in this example, really speaking, there's a predefined relationship, pre-existing relationship between A and C when A agreed to...
Or B and C for that matter.
Yeah. A, B, and C, Mr. You are A or you are C. Mr. Khambata is A and Mr. Diwan is B.
Correct.
So when A agreed to supply goods to B, and there is obviously in your example, there is exchange of correspondence, there is an exchange of emails, there is an exchange of communication between C and A and B, and by which C also is intrinsically a part of either the negotiations or the performance or the execution of the contract. These cases may not be that difficult. Question will arise where C has completely stood separately and away from the contract.
Bystander.
He's a bystander. But there is a pre-existing relationship between A and C, which is what you, I'll just go back to your, the way you have formulated it at page 7. An agreement, arbitration agreement as understood under the Act is not a conventional agreement only. Fair enough. An arbitration agreement can take place whenever certain disputes arise among entities when such entities have a defined legal relationship.
That exists as must.
That is your relationship with C's relationship with A. Then C.
No, with the dispute.
With the dispute.
No, exists not with the parties. Existence of a defined legal relationship was a dispute.
With the dispute.
Was the contract, I would say, was the contract.
We'll add in B then. Have a defined legal relationship with the dispute or the contract.
Or contract. I may not be a signatory to the contract, but I have from the exchange of correspondence by some action. For example, my lord.
So long as we say with the contract, I think then it becomes a little more structured. Once we add with the contract.
Correct, my lord. For example, there is a tender floated by Mr. Diwan, and my learned friend Mr. Khambata is participating, where there is a requirement that some company having more than 500 crores turnover will stand as a guarantor so that he can supply the goods to him. I am that company. I stand as a guarantor, and there is an exchange of correspondence. Then it will be, my lord, a fact-specific determination. But I cannot say that because I am not a signatory to your contract, I am out of it. If there is a defined legal relationship emerging from our actions, because therefore the legislature says contractual or not, there can be a defined relationship without entering into a formal contract.
So how does this relationship come in? By your agreeing to be the guarantor in the contract between A and B. So therefore you have entered into or you have acted in a manner which has furthered the contract. So you can't be saying that I am a bystander there. In that,
Therefore, you can't be saying in that case that, look, I'm not a formal party to the arbitration agreement, which was a contract between A and B, which contains the arbitration agreement.
For example, there
But
is a...
ultimately, Mr. Mehta, therefore, it boils down to how you will interpret that particular fact situation.
Exactly. It will
So
have
really, you should not be laying down
fact-specific determination.
You should not be laying down extremely rigid or tightly controlled.
Cannot be and should not be. That's my respectful support.
So then it will be very dangerous.
Yes, well, that cannot be, and that's what I have said, that it will have to be a fact-specific determination. Suppose a Chinese company has a local Indian company as its subsidiary and is entering into contract with local Indian other companies or other individuals, and the Chinese company agree that yes, we are behind it, we are a financially sound company, you can enter into this relationship, and there is an exchange of correspondence, which gives rise to a defined legal relationship. Its relationship is not that of a mortgage, that of a guarantor. The legislature doesn't use a particular kind of defined legal relationship. Any defined legal relationship,
whether contractual or not.
Contractual or not. So that's not my respectful submission. But para 18, your lordships need not read, I'll just orally point out. Your lordships were shown that
what would be examples of non-contractual legal relationships?
Well, non-contractual, I have given some of the examples. There are several theories which have emerged in other jurisdictions. For example, back-to-back contracts. They have a contract. They have to have a contract. I am not a signatory. I am not bound by any defined legal relationship. But I have a back-to-back contract with him. And the facts suggest that I'll supply to him, which he will in turn supply to. So technically, there is no contractual relationship so far as I am concerned. As far as Law Commission's report is concerned, what your lordships have seen. I'm sorry, the report. But Law Commission
B and A materializes and B ultimately supplies the goods to C. Transaction, C is not at all aware what is going on between. One fine day, problems crop up. What do you intend to do? B says, I have taken up the issue with A. I have nothing, how am I concerned? Can C drag A into the arbitration?
Cannot. And the reason is simple. There is no defined legal relationship which came into existence.
So therefore, one or two instances, Mr. Kambata may also assist us. What could be a good example of a non-contractual legal relationship?
Therefore, my lord, in this very example, my lord, I'll point out. C wants some goods, my lord, and he believes that B will be able to supply it. Now, there is an exchange of correspondence between them that I want this description of goods.
You may develop it a little that in this confusion, there may be some correspondence between A and C at a later point.
Exactly, I'm coming to that.
Perhaps C may be able to drag A.
Correct. Exactly, that's what, my lord, in the example which your lordships have given, there does not come into existence any defined legal relationship between C and A. So, this doctrine cannot apply. But when C approaches B, that I want this particular description of goods, and only A will be able to supply because this category of goods or description of goods only he manufactures. You are the retailer or a wholesaler. B approaches A, and there is an exchange of correspondence between three of them. A says, yes, I am agreeable if you enter into a contract as per this schedule of distribution or this schedule of supply. I will be able to supply every month 300 units, and I assure C that I'll supply it to B. Whatever is your financial arrangement, you have your financial arrangement. I can only say that I'll be able to supply. Now, a defined legal relationship comes into existence. He is not just a bystander, as my Lord Justice Roy, my Lord, very rightly, my Lord, coins the word. He is a party to the negotiation. The very fulcrum of the contract is based on his agreement. He is not a signatory in the contract between B and C. But if a dispute arises because of his failure of supply, then he can't run away from the responsibility only on the ground that he is not a signatory to B and C. That's, my lord, the contours of the law.
So again, a fact situation.
It will be very dangerous to set out all the circumstances.
It should not be.
In fact,
should not.
The constitution bench should not even attempt to do
No.
because we must respect the wisdom of the courts concerned.
Fact situation might differ.
Particularly in commercial matters, you must leave a certain degree of flexibility for courts to,
there are two or three things, my lord, why in my
modulate their decisions based on the situation, unless there's something really positively erroneous in the doctrine. Because ultimately you have to evolve the doctrine based on, the facts as they will emerge before succeeding benches.
Therefore, my ultimate, the fulcrum of my argument is that your lordships would decide whether this doctrine is excluded from Indian law, and if not, whether the doctrine is applicable, and the fact situation in each case to be decided, my lord, either at the stage of section 8 or at the stage of section 11 or maybe at the stage of section 16. Somebody may raise a dispute, my lord. Section 11 comes when there is no agreement between the parties and we have to approach the Honorable Chief Justice or his lordship's designate. But suppose there is a dispute between the two of us, we jointly go before an arbitral tribunal, joining C also. He can raise all these issues.
Actually, Mr. Solicitor, the last few words of section 7(1), which may have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. These words define what is the origin of the dispute. or what is the source of the dispute? The dispute, there has to be an arbitration agreement. An arbitration agreement is an agreement to submit disputes which have already arisen or which may arise in future. There's no dispute today, or which may arise in future.
But existence of relationship.
But which may arise between them and in respect of a defined legal relationship, whether contractual or not. So these words, in respect of a defined legal relationship, whether contractual or not, refer to the source
of dispute or
source
the
of
contract.
The dispute must arise either through a contract or it may arise through a legal relationship other than a contract.
Yeah.
So, for instance, I'll give you an example. It may sound a little, I just concocted it here. Suppose a builder has a large tract of land. He carves out plots and assigns plot A to A, plot B to B, plot C to C, plot D to D, plot E to E. Now, there is no contractual relationship between A, B, C, D, and E.
Correct.
Right?
Complete bystanders.
So the contractual relationship is only between the builder and A, the builder and B, the builder and C. But suppose in future a dispute arises between the individual purchasers over the sharing of common amenities or the sharing of a common source of water or a green area, so on and so forth. There might be then an arbitration agreement which says that any dispute between them, A, B, C, D, and E, will be arbitrable. Because then there is no contractual relationship between A, B, C, D, and E unless they've entered into a cooperative society or a condominium. But by virtue of the fact that they are neighbors, there is an element of a legal relationship, what you shall do and what you will not do to a neighbor. Okay, so therefore that is a sort of a dispute which may be an arbitrable dispute in the future. There's no contractual...
but in this section 7 doesn't talk about arbitration contract. So it is talking about arbitration agreement. Agreement is defined under the Contract Act, where there is an offer and an acceptance. Contract is defined as an agreement which is enforceable in law. So there are two legal relationships. One is a legal relationship of a contract, another one is a legal relationship of an agreement. Contract Act contemplates entire regime with respect to how to enforce a contract and also how to enforce an agreement. So far as agreements are concerned, 68 onwards talk about certain relationships resembling those created by contracts. So therefore, those aspects which have not emerged into contracts can also be subject matter of an arbitration. So therefore, it's a holistic.
Yes.
An arbitration can be with respect to enforcement of contracts. It can be with respect to, that is more or less similar to specific performances.
Correct.
So which is also, though it's not a contract, nevertheless, it has come within the fold of an arbitration agreement. That is how it takes within.
Yes.
Now, apropos, to take it a little further, what Arbitration Act is talking about when it's speaking under Section 7 of arbitration agreement, there are three inviolables there. First and foremostly, written agreement is necessary, not contract, written agreement. Second is parties are necessary, but these two are not frozen. 4B gives meaning to it, saying parties as well as legal relationship is inferable from what is defined as the record of agreement. So
not
we have
agreement in writing, but record.
What the court does is, court has in every case look into the existence of parties. That's also inferable from the record of agreement. Court will also have to see the legal relationship, which is also inferable from the record of agreement. So we will have actually a written agreement, not in terms specified as A and
act
B.
Of agreeing.
A and B, but whether A, B, C, or D are inferable from the record of the agreement. And similarly, the relationship is also inferable from the record of agreement. So really speaking, coming to the question, what is
What
the
are we
constitutional
deciding?
bench supposed to do? It's already there. Why this
But
reference?
the argument was
We can
that
perhaps
the
discharge the
doctrine, the argument was that there is an exclusion of the doctrine.
There's no
There
specific
is the
subject to
judgment
hearing,
which is
Mr. Rai.
staring in our face.
Lord, another thing. Lord,
There's no
apropos, my
specific
lord,
exclusion, as you rightly said.
Lord, apropos, my lord Justice, my lord.
I'll give you another example of a legal relationship which was not contractual, which can be subjected to arbitration. Suppose there are 5 brothers and sisters. They have a common property. They want a partition of the property. They want their shares to be identified, or the shares are given in law, but they want a division by metes and bounds. There's so many arbitrations which take place. There's no contractual relationship between the members of a family. If they are partners, there's a contractual relationship.
So, Lord,
because then there's a partnership agreement.
Your Lordship, sir.
But if there is a non-partnership dispute between, say, members of a family, you can submit that dispute to arbitration. What is excluded, of course, is just that, just as Ravindran said, where it's, in rem, then you can't.
That's correct.
So you can't, it's a will.
So
the will operates in rem. Once will is probated, probate can't be referred to arbitration.
So it's in rem.
Or, that's right. Or something which is determinative of legal status, like the paternity of a child. That you can't refer to arbitration. As just Ravindran carved out, admiralty.
1, 2, 3. My lord, 3 areas are covered. Lord, now, apropos, my lord, your lordship, my lord, the
Therefore, when you agree to an arbitration, the dispute may not emanate from a contract at all. It may emanate entirely from an area other than a contract. That's right.
Look, kindly, my lord, test your lordship's example, my lord, again for 7-1. Again for 7-1, my lord. Kindly, I'm sorry. My lord, Justice Narasimha.
No, nothing, sorry.
No, I'll do that.
Yes, Mr. Mehta. So,
yes, Lord, taking your lordship's example, just my lord, then I'll move on to the other point. Lord, kindly see 7-1 in a scenario which my lord, the Chief Justice of India.
absolutely.
Matter of fact, discovery, chair, and etc. Your lordships have examined the fact-specific situations. In fact, it never required a reference. I'll assist your lordship. Can we come to 7-1 again, my lord, in the context of your lordship's illustration that a builder having a separate agreement contract with A, with separate with B, separate with C, and some dispute between A, B, C, D. Now, please see, it is in this part, arbitration agreement means an agreement by the parties. So, builder can't be roped in unless there is something to suggest that he also has acquired certain responsibilities.
Way that dispute.
And it should be resulting into some kind of a defined legal relationship, which may be contractual, which may not be contractual, which may be, my lord, arising in case of, my lord, illustration like this nature, my lord, easement. Whatever, my lord, I'm not giving examples. My lord, now I'll move forward. My lord, there was a reference that there is a Law Commission's report. Lord, 246th Law Commission report. I'll finish it in 5 minutes, this Law Commission report one. Lord, there was a suggestion. There were 2 suggestions. Lord, page 7. A. The Law Commission merely recommended amendment to section 21H, that is parties, and not to section 7 of the Act. In other words, even the Law Commission did not find that without amending both section 21H and 7, group of companies doctrine cannot be statutorily recognized. They never said that you amend section 7. B. The said definition was not required to be mandated as the suggested definition If read, my lord, your lordships can skip, my lord, I have reproduced and possibly somebody has read, my lord, 61 to 64 of Law Commission's report before your lordship. But see, when section 7 provides for a permissible dispute resolution, even amongst the third party, even if they are not contractually bound with each other, mere enlarging the scope of the term party to add person claiming through or under such party, that was the amendment suggested, may perhaps restrict the wider meaning of section 7. And therefore, my lord, maybe that is not accepted. Lord, I hope, Lord, I am able to make myself clear. Section 7 is very widely worded so as to include every kind of legal relationship if there is an agreement shown to exist, whether agreement is contractual, not contractual, irrespective of that. Now, if the definition of section 2(1)(h) is amended, it would restrict that either person claiming through him. So possibly that can be the reason it was not, my lord, amended. The officer of the law ministry is here, my lord, with the record. I don't want your lordship to see, but if your lordship wishes, I can place it, my lord, and your lordships can see them. I can show it to others.
Is there anything specific in that?
Lord, the only thing is, my lord, that there is a table. The Law Commission suggested several amendments. Left-hand side column mentions the suggested amendment. Right-hand side column mentions the response of the law ministry. On 2(1)(h), they say should be accepted. But thereafter, it never materialized when a bill was prepared, which became an act in 2015, the Amendment Act. So that is.
So it was accepted in the law ministry, but it
didn't materialize, and there is nothing on record we have checked up to show why that happened, whether inadvertence, a conscious decision.
Gone up in the pool.
To explain that restrictive meaning was avoided.
Yes.
They wanted to keep the expression enough to take into account all kind of possibility scenarios.
As contemplated under 7.
As contemplated under 7.
Otherwise,
that 7 is wide enough to take.
2(1)(h) as suggested to be amended may perhaps restrict 7. Because then it would be party. Party would mean either party himself or someone claiming through him. Then, even if there is a defined legal relationship emerging, even if an act of agreeing, without there being any formal agreement emerging.
But the notes in the ministry do not suggest that consciously such a decision with this intent.
It is not. I must frankly, my lord, admit
it was just not gone through. Although
it didn't go through, my lord. That's all. But I'll place, my lord, the file for your lordship's consideration. Lord, section 8, I don't wish to, my lord, dwell much. It merely gives an additional locus. Earlier, my lord, what used to happen, if contracting parties are before a civil court or any judicial forum, only the party can say that send us to arbitration or send them to arbitration. Now, my lord, even any other person claiming through or under him also can. It gives additional locus in section 8, nothing beyond it. My lord, it doesn't affect the applicability or otherwise of the group of companies doctrine.
Yes.
Lord, page 10, para 22, my lord, the heading, my lord, I'll not, my lord, dwell much, but my lord, I'll just orally point out in 2 sentences that the very object of the act is to ensure that dispute A is resolved fast. This second, it is not fragmented. If someone is really a part of a defined legal relationship, then I'll fight with A in an arbitration and I'll fight with C in a civil suit. That is avoided. So your lordships would avoid a meaning which defeats perhaps the intention of the legislature. Lord, now page 11. Lord, your lordships may not again read it. I'll just orally point out what my submission is. May I read, my lord? Or
yes. Page 11.
11, para 28. Lord, the submission is that every jurisprudential doctrine may not have its foundation or basis in a statute, Lord, Lord, without reading it, I'll just orally point out what my respectful submission is. Lord, the legislature provides the letter of law.
Yes.
And your lordships, by judicial interpretation, infuse the spirit and blood in it. And that is, my lord, the doctrinal approach. Lord, for example, doctrine of estoppel, the doctrine of legitimate expectation, nowhere to be found in any statute.
Promissory estoppel.
Promissory estoppel, my lord. There are, my lord, the doctrine of piercing corporate veil. It's not part of any statute. Doctrine of proportionality. It's not a part of any statute that it has the punishment or act should be proportionate to what is being dealt with. Then doctrine of causes omissus. So, my lord, jurisprudence evolves once the letter of the law is interpreted by your lordships and your lordships infuses blood and soul in that letter of law provided. If it defeats the very intention of the act, my lord, it cannot be accepted. Suppose there would have been a doctrine in the arbitration context which would have defeated the very object of the act. Then your lordships may, in a 5-judge combination, say that no, this doctrine is not applicable. But it furthers, my lord, the object of the act. It supplements the intention of the legislature. So now the question is, when there is statute silence in the statute law, can the doctrinal approach be incorporated while dealing with that law? So to put it differently, when this was an argument that when there is no reference to group of companies doctrine, can you read that into section 7 or any other provision merely as a doctrine which is evolved by judicial interpretation? Lord, there is a recent judgment of the United States, my lord, United States Supreme Court, my lord, and allow me to read that page 30 in arbitration. In arbitration, my lord. Lord, therefore, my lord, before I read it, my lord, please examine. There are several countries broadly classified as those who have adopted the model law of UNCITRAL, those who have not adopted the model law of UNCITRAL, but all have their domestic laws, maybe fully in conformity with UNCITRAL, maybe partly in conformity with UNCITRAL, maybe completely different from UNCITRAL. Whether they can use the doctrinal approach or not, as per their domestic policy. Suppose India is UNCITRAL compliant law. Can we not have some doctrine? Lord, that is answered by the Supreme Court of United States at page 13. Lord, the citation I have given, Lord, and I have placed, Lord, the judgment also, Lord, GE Energy Power Conversion Finance. Lord, para 13, Lord, may I read this judgment, Lord? This silence is dispositive here because nothing in the text of the convention could be read to otherwise prohibit the application of domestic equitable estoppel doctrine. Now, please mark it. Equitable estoppel doctrine is a facet of group of companies doctrine. I'll show you. Equitable estoppel doctrines. Because I will be stopped from saying something which I did, which resulted into a defined legal relationship. Only one article of the convention addresses arbitration agreements, Article 2, and only one provision of Article 2 addresses the enforcement of those agreements. Article 2.3, the text of Article 2.3 states that courts of a contracting state, like India, but India would be a contracting state in this context, shall refer the parties to arbitration when the parties to an action entered into a written agreement to attribute and one of the parties requests referral to arbitration. The provision, however, does not restrict contracting states from applying domestic law to refer parties to arbitration in other circumstances. That is, Article 2.3 provides that arbitration agreements must be enforced in certain circumstances, but it does not prevent the application of domestic laws that are more generous in enforcing arbitration agreements. Now, please mark this, Lord. Article 2.3, that is UNCITRAL, contains no exclusionary language. It does not state that arbitration agreements shall be enforced only in the identified circumstances. Given that the convention was drafted against the backdrop of domestic law, it would be unnatural to read Article 22(3) to displace domestic doctrines in the absence of exclusionary clause. There has to be a statutory provision excluding the doctrine. In absence, doctrinal approach will be available to the courts while interpreting the arbitration agreement. This interpretation is especially appropriate in the context of Article 2. Far from displacing domestic law, the provision of Article 2 contemplates the use of domestic doctrines to fill the gaps in the convention. For example, Article 2(1) refers to disputes capable of settlement by arbitration, but it does not identify what disputes are arbitrable, leaving that matter to domestic law. Then, my lord, some judgment is cited. Similarly, Article 2(3) states that it does not apply fails to define those terms. Again, the convention requires courts to rely on domestic law to fill the gaps. It does not set out a comprehensive regime that displaces domestic law. Some, the only provision of the convention that addresses, dear lordships, can, my lord, lord, 14. In sum, the only provision of the convention that addresses the enforcement of arbitration agreement is Article 2(3). We do not read the non-exclusive language of that provision to set a ceiling that tacitly precludes the use of domestic law to enforce arbitration agreement. Now here one can read, my lord, doctrine. There is no exclusion by the statute. Statute could have excluded. Statute could have excluded, subject to, Lord, meeting with your lordship's test if challenged. Lord, New York Convention, my lord, I have addressed your lordships. My lord, I will not take your lordships to, my lord, that. Kindly come to page 17 directly, my lords. Some of the parameters which are considered, my lord, we have examined for your lordship's assistance. And, my lord, it would be your lordship's pleasure, my lord, whether I go into this in detail or not. I may not go to, if your lordship, my lord, feel that it might unnecessarily consume time. But the exercise is this. What are the parameters considered by other jurisdictions of the world to incorporate, to accept the group of the company doctrine? It's not just a group of the company, that somebody is a company and is group company of somebody else. That's not the only thing. Lord, please come to, my lord, page 19. Representation, agency and apparent authority. Often theories of agency and these are illustrative. These are not exhaustive. It would depend upon the fact-specific situation. Often theories of agency and representation are relied upon to bring an arbitration claim against a party who is not signatory or a part of an arbitration clause. Though the exact meaning of the agency and representation is different in each jurisdiction, the fundamental principle is that one party, acting as an agent, execute a contract on behalf of other party, which will be the principal. Then irrespective of who the signatories are, both are liable. In this kind of scenario, questions have arisen as to whether the principal authorized the agent with categorical power to enter into and bind the principal in the arbitration clause, or the power so conferred was general authority to enter into a contract which is a substantive contract. But most of the case law is on this, that I authorize my agent to enter into a contract, but my authority can be specific. That, all right, you bind me even for arbitration, or my authority may be limited. That bind me in the main substance of the contract. If there is a dispute, two of you settle. That would be fact specific. Variety of situations have arisen under this head. If from the agreement, whether an agreement in conventional sense or an act of agreeing through correspondence or other acts, expressly confers power on the agent to bind the principal, even with regard to the arbitration generally, the doctrine is made applicable and the principal is joined in arbitration proceeding and is bound by its outcome. Now, my lord, some jurisdictions have gone a step further. There may not be any express authority, but a presumed or ostensible authority. Somebody, my lord, gives an impression that I am authorized and the principal doesn't object by his act of commission or omission. Please see, my lord, absence of actual authority in some jurisdictions, the courts are also examining whether a party not mentioned in the arbitration clause should still be bound on the basis of apparent or ostensible authority of the party, which is a party to the clause or substantive contract. In the event of a party initiating arbitration against a non-signatory or a non-party, the claimant will have to satisfy two conditions. But these are the broad conditions, my lord, which are generally found in all jurisdictions when it's a question of fastening the responsibility based on ostensible authority. A, the principal had very apparently induced by way of a false representation the claimant to believe that the agent had the authority to bind it in an arbitration clause. B, such misrepresentation can also be implied based on the existence of undeniable and intricate business and corporate links between an ostensible principal and or the ostensible agency, which can reasonably lead the claimant to believe the existence of such an authority. This will again be a subject matter of fact situation in each case. Lord, I can skip, Lord, others. Kindly come to third party beneficiary. Lord, some jurisdictions, my lord, to how far, my lord, this court would accept again would depend upon the fact situation. But if in a contract between A and B, it is explicitly mentioned that it is for the benefit of C, and C has derived some advantage under the contract, he cannot take the plea that he is not a signatory and therefore would not be bound in the arbitration. Then party taking direct benefit. Now, I have given some judgments also. Lord, I don't think, my lord, I should read those judgments, but this is for your lordship's assistance. And we have placed, my lord, the copies of the judgment, my lord, if your lordship considers it at your lordship's, my lord, leisure to read. Then, my lord, incorporation by reference. My lord, I am not reading it. I'll just generally give the overview, my lord. There are judgments, my lord, which I have cited in the footnote. Lord, in some jurisdictions, what happens is a contract is between A and B. C is completely alien to the contract. But the contract refers that for the performance of the contract by A with regard to B, C has, by later dated so-and-so, agreed to do this. C has, by act, supplied something. C has, by his act, purchased something. So, my lord, in fact situation like this, incorporation of responsibility even by implication or reference made in the agreement with regard to a party who is not a signatory to the argument, that is also, my lord, accepted, and that is also, my lord, an extended group of company doctrine. Then your lordships may come to 24, doctrine of single economic entity. My lord, the case of discovery which my lords decide, where the registered office of the company and the subsidiary was on the same place, the chartered accountant was same, several things were being done together, one was representing other and other was representing one, my lord, respectively, etc. Then, my lord, parameters, my lord, which are, my lord, if your lordships can quickly go through 24 bottom. My lord, these are examples. Basically, my lord, as I say, my lord, these are illustrative lists, cannot be an exhaustive list, my lord. But there are several, my lord, illustrations I have given. Then, my lord, since I am not wasting their time, my lord, I am not going into it. Equitable estoppel doctrine, single employer liability, controlled group. Lord, there are several facts which emerges before your lordships. That this is controlled by this group. This is just money going from right pocket to left pocket. Then also, my lord, it has done. Then economic realities tests. There are some judgments, my lord, on that, where group of company doctrine is applied, joint employer doctrine, etc.
Yes.
Now, my lord, what would be last, my lord, my submission? What would be the contours? My lord, suppose your lordships were to hold that as a doctrine, group of company doctrine is accepted. At the stage of section 8, or at the stage of section 11, what extent your lordship's examination would be. My lord, earlier there was a 7-judge bench judgment, that is, my lord, SBP and Company versus Patel Engineering Limited, page 32, my lord, and I have quoted.
Yes.
I am not reading it for a reason which will come subsequently, my lord. My lord, here it was, my lord, pre-amended situation. My lord, kindly, my lord, take this a little, my lord, kindly consider this. My lord, prior to the amendment, my lord, the Chief Justice or his lordship's designate under section 11(6) was supposed to look at only the existence of arbitration clause, nothing beyond that. This judgment of the 7 honorable judges of this court was based on the earlier law. Thereafter, the law changed. And, Lord, a little wider jurisdiction, my lord, now is available with the Honorable Chief Justice or his lordship's designate lordship. Now, kindly come to para 35. After that, my lord, Vidya Drawlia comes. And it says that now, in view of the amendment in the Act, namely section 11(6), this Patel Engineering is not an applicable law. It could not have said good law. It's not an applicable law because of the change of law. And, my lord, this judgment, my lord, subject to, my lord, being pointed out contrary to this, my lord, holds the field today. And I don't think, my lord, there is anything which can be objected to. This is the test laid down. Lord, it's a 3 honorable judges. Justice Khanna wrote, Lord, the majority view, and then the Honorable Chief Justice, Lord, wrote a concurring supporting. May I read, my lord, or leave it at that?
That's okay. I think we can do it.
Yeah.
Lord, I have also, Lord, given that, my lord, and my lord, I have also said that apart from section 8 and section 11, another stage is section 60, where, my lord, this issue can be raised and can be considered. Only last argument, my lord, which is not a part of my written submissions, but in the morning, my lord, I could think of it. Please come to section 28, my lord, and I'm done. I'm not I'm not, Lord, repeating anything. 28. But the group of companies doctrine has its root in equity, because your lordships do not desire multiplicity of litigation and one-stroke dispute resolution solution under the arbitration clause. And your lordships can evolve that doctrine, that's the submission, rules applicable to substance of dispute. Lord, please see 2. The arbitral tribunal shall decide ex equo et bono or as amiable compositor only if the parties have expressly authorized. Meaning thereby, this restriction that you cannot have any doctrinal approach is not restricting arbitral tribunal's jurisdiction, not your lordship's jurisdiction. Your lordships can say that this doctrine is the doctrine which is in furtherance of the intent of the Act. And 3, while deciding and making an award, the arbitral tribunal shall, in all cases, take into account the terms of the contract and trade usages applicable. Your lordships are also, my lord, while applying doctrinal approach, not bound by the terms of the contract.
Suppose we say that the arbitrator shall decide.
Then
what happens?
No, my lord. Then also, kindly see me. He will go by, my lord, the trade, 3, trade usage. That yes, in this particular trade, this is perfectly usual. Lord, really speaking, the tribunal would decide that issue, not under 28, but under 16. Under 16, whether there is an arbitration whether we have the jurisdiction on arbitral tribunal's jurisdiction. Here, the tribunal would be bound by a lordship's doctrine, because that's the judicially evolved doctrine, and not bound by the terms of the contract. Lord, these are my respectful submissions.
Thank you, Mr. Solicitor.
Lord, I have given, my lord, the judgments and, my lord, some which we found, my lord, to be useful and, my lord, assisting your lordships, which is already filed. I'm not reading it. Your lordships can, my lord, if your lordship feels, just glance through it, it would, my lord, assist the court, my lord, in arriving at it.
Thank you, Mr. Solicitor.
Lord, immensely grateful, my lord, for the intent. Lord, would your lordship, my lord, I'll just place, my lord, that file,
Sorry?
the file of the law ministry, your lordship,
Not necessary, I think.
to them and thereafter.
Not necessary.
Please, your lordship.
Will be adopting the same line as the solicitor or?
Not exactly, my lord. I'll tell my lord broadly the line I'm adopting.
Your lordships can pardon my absence for some time, right?
Now, Mr. Kambata is going to argue, then Mr. Ritin Rai, right? Yes. That concludes everybody.
Mr. Devan is, I think, also there.
All right. How long would you take, Mr.?
But I would take about 2 hours. I'll try and
About
curtail it.
2 hours.
I'll try and curtail it. I put my submissions
All
in
right.
writing.
And Mr. Rai?
Lord, I've been through Mr. Kambata's submissions. I have something to add, which I've also put in my submissions, my lord. I had anticipated, my lord, 2 hours myself, but I'll take much less than that. Lord,
Okay.
But
So that means it will not get over today.
yes, my lord, because I have some differences from
What
the
Mr.
other-
Kambata is
but
arguing.
even to
So today, probably Mr. Kambata will get over today.
yes.
And then then we can keep this thereafter just to keep the format and the time schedule on the 11th because
Yes, yes.
10th is the miscellaneous
Opening
day.
day.
Next week we have 2 days which are going to be miscellaneous.
Miscellaneous.
10th will be miscellaneous. Then 11th we can take we can hear Mr. Rai for the morning session.
Yes.
Morning session you can wrap up. So then we can conclude
The other side.
matter by the morning session.
Tomorrow is also, my lord, miscellaneous. day.
Tomorrow is miscellaneous because the day after is a holiday. So.
We're grateful, my lord. The break is a bit unfortunate because it breaks the continuity. for
Yeah,
you.
absolutely.
We're grateful.
My lord,
So
generally it is said, my lord, that never give lawyers an overnight to think. The arguments are always lengthened.
Which is why it's good everyone's put it in writing.
Kambata, Alison, you got your compilation and your written submissions also.
We filed it.
So then you can just take us to navigate us.
I will do that.
We'll come back at last.